So, as I said, welcome back again to this webinar. This webinar is presented by IOFX Immigration Partners, and I am Dr. Felix, the lead consultant and the CEO at IOFX Immigration Partners. So today we'll be looking at the A to Z of EB1 and EB2 NIW. So everything you need to know about America's premium self-petition pathways. So what that means is that if you're in the US or you're outside the US, you do not need an employer to file for you. You do not need somebody to file a green card for you. You can file the green card by yourself. So in this webinar, we'll be looking at how to go about it, how to file for green card by yourself. So this is today's roadmap. What I'm going to do today we'll be looking at the definition of EB1 and EB2, the differences between both of them, and who qualifies. We'll also take a deep dive into the Kazarian two-step and all the 10 criteria that are required to meet to get your case approved. And we'll also do an EB2 NIW deep dive, and we'll look at the Dana's three-prong framework. Now, we do a comparison between EB1 and EB2 so that you know which one works for you and which one you should go for as far as applying for a green card is concerned. And I will also teach you how to build a winning case, how to write a winning petition when filing for EB1 or EB2. We also look at the RFE response strategies in case USCIS pushes back, USCIS denies your petition, how to push back, how to appeal, and how much it will cost you. That is how much the US government is going to charge you to file for EB1 or EB2. And then you have an opportunity to ask your question. So what are EB1 and EB2 NIW? So EB1 is for alien of extraordinary ability. It is a first preference employment-based visa, and it doesn't require any employer sponsor for you to apply. You don't need to have a job offer in the United States to apply, but you must show sustained national or international acclaim when applying. You can self-petition. That means that you don't need someone to file for you. You don't need somebody to petition for you. You can petition by yourself, write it by yourself, or engage the services of somebody to help you write it. And when and if you get approved, then you can get a green card. And then the priority date is often current for most countries. What that means is that if you file or you apply for it and you are then approved, you can get a green card easily. You don't need to wait. Now, what is EB2 NIW? EB2 NIW, or National Interest Waiver, is a second preference employment-based visa. So you see, we have EB1 that is the first preference, and while we have EB2 that is the second preference employment-based visa. So one is higher than the other in terms of requirement, in terms of conditions, and in terms of standard. EB1 standard is very, very high, but EB2 standard is lower than EB1 standard. So as far as EB2 is concerned, it waives the perm labor certification. You do not need an employer to file for you or to petition for you. You can do that by yourself, but you must show that your work in the US is in the national interest. You can self-petition also, and it has a lower bar than EB1. Now, as I go through my slides, if you have any questions, just feel free to put your questions in the chart, and I'll be looking at the chart to see how to respond to questions from time to time. Now, we are going to do a deep dive into EB1, and then we will look at EB2. Okay, so EB1 has 10 criteria, and you need to meet at least 3 of them. So let me take it again. EB1 has 10 criteria, and you need to meet at least 3 of these criteria for your petition to be approved. Even when you meet the 3 criteria, then the officer will move to the second step, which is called the Kazarian step, where the officer looks at the totality of the evidence to see whether you meet the high standard of EB1. So there are 2 steps in EB1. The first step is for you to meet 3 criteria out of these 10 criteria that you are looking at right now. And I will do a deep dive into these 10 criteria. And then in the second step, the officer now looks at the totality of the evidence to see whether you are someone who has risen to the very top of their field in your field. So let's look at the criteria one after the other. So remember, I said that there are 2 steps in EB1. There are 10 criteria. You need to meet 3 criteria. So when you meet 3 criteria and the officer has determined that you meet 3 criteria, then he or she moves to the second step of the adjudication, where they look at the totality of the evidence that you presented to determine whether you are someone who has risen to the very top of your field. So what are these criteria that you need to meet? Remember, you need to only meet 3. So the first one is awards. That is receipt of lesser nationally or internationally recognized prizes or awards in your field. So if you have received awards in your field, awards, national awards, international awards that show that you are an excellent person in your field, you could claim this criterion. The second one is memberships. Membership in associations requiring outstanding achievement of their members. So if you belong to an association that requires that you have outstanding achievement, you know, there are some associations that you just need to pay to become a member. However, there are some associations that you need to show proof of extraordinary and outstanding achievements for you to become a member of that association, or for you to become a fellow of that association. If you belong to such associations, then you can claim criterion 2, that is membership. Now, the third criterion is press or published material about you in major media, that is publications. Let's say that you are published in CNN, your work was published in Fox News, your work was published in Vanguard in Nigeria, or in US Times, in The Guardian, in Nigerian Tribune, or any major media in the US or outside the US, then you could claim this criterion. So publish material about the petitioner in major media, either in the US or outside the US. Right? Now, the fourth criterion is judging the work of others in your field. So if you have served as a judge of the work of others in your field, maybe you've been on interview panels, or you've been an associate editor of a journal, you've been an editor of a journal, or you peer reviewed the work of other people in your field, then you can claim this criterion. Now, the fifth criterion is original scientific scholarly, artistic contributions of major significance in your field. If you've had original scientific, scholarly, artistic contributions of major significance in your field, then you could claim this criterion. The sixth criterion is scholarly articles. That is authoring scholarly articles in professional journals. So if you have authored scholarly articles in professional journals or in academic journals, then you meet this criterion. And number 7 is exhibitions. That is the display of your work at artistic exhibitions or showcases. This is more related to artists. So if your work has been displayed at artistic exhibitions or showcases, maybe you are a musician, and then you sang in a concert, or you are an artist and then you displayed your work in an artistic exhibition, then you could claim this criterion. The 8th criterion is leading or critical role, performing leading or critical role in distinguished organizations. That is, you perform a leading or a critical role in a distinguished organization, then you could claim this criterion. Number 9, the 9th criterion is commanding a high salary relative to your peers in your field. So let's say that you're working for MTN or you're working for an organization, and then you have commanded a high salary times 2, times 3. You have earned more than people in your position in your field, or you are earning more than people in your position and in your field, then you could claim this criterion. And the 10th one is commercial success in performing arts. Commercial success in performing arts. And again, this is for people that are in the realm of art, artists, filmmakers, producers, and so on and so forth. So, what if you want to file for EB1? These are the 10 criteria that you need to meet, and you need to meet only 3 out of these 10. So, if you meet 3 out of these 10 criteria, then the officer will move to the second step of the adjudication to look at, okay, let's look at this. This person has met 3 out of the 10 criteria. Now, when I look at this profile holistically, can I confidently say that this person belongs to the people who have risen to the very top of their field? So at this level, that is the question that the officer will be asking themselves. So another name that is given to EB1A is the Einstein visa. I hope all of you know Albert Einstein, the famous scientist. So that is, you know that he came up with a lot of inventions and he has contributed a lot to science. So he has risen to the very top of the field. So that is another name for EB1. That shows you how high the standard is. How high the standard is. So I spoke to you about the first step. That is, in the first step, you only need to meet 3 out of the 10 criteria. Now, in the second step, that is called the Kazarian second step test. So these are how USCIS officers must evaluate your EB1 petition. As I said, in the first step, they ask themselves, has this petitioner met 3 out of the 10 criteria, or has he or she provided evidence of one-time major achievements such as Olympic medal, Pulitzer Prize, etc. So it means that even if you have a major prize, maybe you won the Olympic, Pulitzer Prize, and so on and so forth, you don't, that replaces the 3 criteria that you are supposed to meet. So officers must count qualifying criteria. So at this level, they don't weigh the quality at this step, but all the submitted evidence must be considered. And the common error that officers make at this level is that they usually skip to the second step without completing the first step. So what happens at the second step? At the second step, the officer does a holistic review of your petition. They look at the totality of evidence and they ask themselves this question: does the record as a whole show sustained national or international acclaim? And they ask themselves, is this petitioner among the small percentage of people at the top of the field? So these are few questions that they ask themselves. So they also look at the quality or the quantity of evidence. So, and this is where IOFX strategic framing wins cases here. So this is where we can actually help you, because I've seen people who file it by themselves and for themselves, and then they met 5 or 6 criteria, and then at the second step they failed, and that was how their petition was denied. So you don't want that to happen to you. So you need to understand very well what USCIS is looking out for, and once you understand that, you'll be able to put your best foot forward. Are we together? If you're following me, let me see your fire emojis. Let me see your fire emojis if you're following me. I'm looking at the chat. Let me see your fire emojis, your love. Okay. Okay, good. Now we have looked at EB1. Remember that I told you that EB1 has 2 steps. In the first step, you need to meet at least 3 criteria. And when the officer determines that you have met at least 3 criteria, they then move to the second step. And the second step is where cases are won or lost. I've seen several people who met 3, 4, 5, 6 criteria. And the officer says that, oh, you know what, I'm not convinced that you are among the people who have risen to the top of the field. So meeting 3 criteria in EB1 is the easiest. Now convincing the officer that you have risen to the very top of your field is another matter. So the crux of the matter is at the second step. And at the second step, you need to show the officer that, yes, I have risen to the top of my field, and this is what shows that I have risen to the top of my field. In my field, the ordinary professor or the ordinary researcher produces 5 articles per year. I have produced 10 or 15. The ordinary researcher or professional in my field has maybe 20 citations. I have 50. So it means that puts me at the top of my field. The ordinary professional in my field earns $5,000 per month, and I am earning $8,000 per month for the same position and the same years of experience. So it means that I am among the top people in my field. And then after showing that you have really risen to the very top of your field, you need to show that your acclaim, another word for acclaim is recognition, another word for acclaim is prestige, that your acclaim has been sustained over a period of time. Now, it needs to be sustained for at least 3 years and beyond. That reminds me of someone who filed EB1 by themselves and for themselves, and then they met 6 criteria, But there was a problem with that profile. All the evidence, the pieces of evidence, all the recognition that they had gotten had happened in 1 year or less. So the officer is saying that, okay, here I can see that you have won awards. I can see that you're a member of this association. I can see that you have this scholarly article. I can see that you have this criteria and this criteria. But all of this happened within 1 year. How is that sustained? That is why I say that whenever you are talking about sustained acclaim, sustain, another word for sustain is continuous or continued, something that has happened over a period of time. I would like you to go for at least 3 years and beyond. So if you have published articles, you have awards, you have membership, you have leading or critical role, you have salary, ensure that all your pieces of evidence, ensure that your achievements cross or are cut across 3 years or more than 3 years. So that is how you can show that your achievements have happened over a period of time. All right, good. If you have any question, please drop your questions in the chat. I'll be responding to them later on. So now let's look at EB2 NIW. Let's look at the diagnoser framework. So remember that in EB1, I was talking to you about 2 steps. In the first step, there are 10 criteria. You need to meet 3 out of the 10. And the second step, that is where the totality of the evidence is actually being looked at and being reviewed. Now, in NIW, EB2 NIW, there are 3 steps or 3 prongs. The first prong is substantial merit and national importance. The second prong is you showing that you are well positioned to advance your proposed endeavor. And the third prong is you showing that on balance, waiving the labor certification will be in the national interest. Now, who can file for EB2 NIW? Who can file for EB1A? You don't need to have a degree to file for EB1A. You can have an associate degree, you can have certifications, but if you have a degree, it could help your case. So there is nowhere in the regulation that says that you need a bachelor's degree, a master's degree, a PhD to show that you have risen to the top of the field. The main difference between EB1 and EB2 is that EB1 talks about what you have done in the past, your achievements. EB2 talks about what you will do. So EB1, so as far as EB1 is concerned, you want to show that you have risen to the very top of your field. You can rise to the very top of your field without having a PhD. You can rise to the very top of your field without having a master's. I've seen people with a bachelor's degree who have gotten EB1A approved. I've helped several people with a bachelor's degree get EB1A approved. So there is nowhere in the regulation that says that you must have a bachelor's degree, a master's degree. That is for EB1. Now we're talking about EB2 now. There are 2 parts to EB2. Now there is the advanced degree part and there is this exceptional ability part. There is the advanced degree part, there is the exceptional ability part. So the advanced degree, so if you want to go for EB2, if you have an advanced degree could be a master's or a PhD, you can file for EB2 NIW. So you can have a master's or a PhD or a bachelor's degree plus 5 years of experience in a particular field. You can file for EB2 NIW. Now, as I said, there is the exceptional ability part. There are 6 requirements that if you meet 3 out of them, even if you don't have a first degree or a master's degree, you can still file for EB2 NIW. So, after you establish your eligibility, as far as EB1, EB2 is concerned. Remember that I said that for EB2 you need to have at least a bachelor's degree plus 5 years of experience in a particular field, a master's degree, or a PhD, or if you would like to go the exceptional ability route, there are 6 requirements that USCIS has laid down, and if you meet 3 out of those 6 requirements, then you will be eligible to file for EB2. So after that we have ascertained your eligibility, the next thing for you to do is to have a proposed endeavor. A proposed endeavor. What is a proposed endeavor? A proposed endeavor is an activity that you intend to carry out in the US. It is an activity that you intend to carry out in the US. For example, an example of a proposed endeavor is that I propose to engage in research that will lead to the cure of cancer in the US. For example, I propose to establish a language school that will close the language gap between Americans and their European counterparts. That is an example. I propose to establish a business school that will serve underserved communities in Urbana, Illinois, or in Manhattan, Kansas, or in New York. That is an example. I propose to engage in research that will combine AI and machine learning to track fraudsters. For example, that is a proposed endeavor. So a proposed endeavor is a specific, it's not a general activity, it must be specific. It cannot be vague. It must be specific. It is a specific endeavor that you want to carry out in the US, or the specific activity that you would like to carry out in the United States. So remember, look at the framework that we are using. Let me backtrack a little bit. We spoke about EB1, and the framework of EB1 is a 2-step analysis. First step is where you need to meet at least 3 criteria, and in the second step is where the officer looks at the totality of the evidence to determine whether you meet the high standard for EB1. Now EB2, the framework is you need to have a bachelor's degree plus 5 years of experience in a particular field, or you need to have a master's degree, or you need to have a PhD, or you could meet 3 criteria out of 6 that USCIS has established to show that you have exceptional ability. So EB2 has 2 routes, the advanced degree route and the exceptional ability route. Then once you are done with that, you have established your eligibility. Then we look at your proposed endeavor. What do you want to do in America? What does America stand to gain by giving you a green card? That is what your proposed endeavor does, which is a specific activity that you would like to carry out in the United States. All right. So after we have a strong proposed endeavor, now remember, your proposed endeavor is the foundation of your case. If you have a weak proposed endeavor, that case will crumble like a house of cards. It will crumble like a pack of cards. So your proposed endeavor needs to be strong, specific, and reliable. So we have established your eligibility. We have a strong and specific proposed endeavor. The next thing to do is to show that this particular proposed endeavor has substantial merit and national importance. So the proposed endeavor needs to have substantial merit. It needs to be beneficial. It needs to be worthy. It needs to have works. It needs to be beneficial. What is the intrinsic value of that work to the United States, not just you? So, and then it needs to have national importance. When talking about national importance, we are talking about the broader scope of your work. It must affect issues beyond your local community. So whenever you're talking about national importance, we are talking about this scalability of the work. What will the work do at scale? What must the work do at scale? That is the first prong of the analysis. So after USCIS or the USCIS officer looks at what you want to do in the United States, if they determine that it has substantial merit and national importance, they are, in the first part, they focus on the work you want to do. In the second part, they now focus on you that wants to do the work. They focus on you that wants to do the work. So, do you have the necessary education, the skills, the record, and the plan to carry out this work? So in this second prong or this second part, you want to show the adjudicating officer that you are well positioned to advance the proposed endeavor that you put forth in the first part. So remember, there are three prongs. Your proposed endeavor needs to have substantial merit and national importance. In the second prong, you need to show that you are well positioned to advance the proposed activity, the specific activity that you said that you wanted to carry out in the United States. And in this part, USCIS looks at your education. They look at your skill. Do you have the skill to do this thing? Do you have the record of achievement? Have you achieved certain things in the past? So they look at your track record of past success in this area, in this particular field, or in this particular, as far as this particular endeavor is concerned, or something related. So they want to see concrete and specific future plans. Do you have relevant publications? Do you have projects that you have engaged in? And do you have citations? This is about you and your qualifications. So the first part is about what you want to do, its substantial merit and its national importance. The second part is about you. Do you have the qualifications to do this thing that you want to do? Okay, at this point, if you're not subscribed to my channel, please go ahead and subscribe to the channel, because I bring out videos every week to help you file a very strong case. So go ahead and subscribe to the channel right now. So in the first part, we look at the substantial merit and national importance. The second part, we look at whether you're well positioned to advance your proposed endeavor. And in the third part, we want USCIS to waive the labor certification. So we want to show USCIS that waiving the labor certification will be in the best interest of the United States. So you want to show the officer that the U.S. interest outweighs labor market protection, because the labor certification was put in place to protect American jobs. So you want to tell the officer that, look, this thing that I want to do is beyond protecting one American job, because what the nation is going to gain from this is beyond protecting one American job. So you also want to show the officer that what you want to do, that is your specific proposed endeavor, is urgent. There's an urgent need in the field, or your expertise is rare, that you cannot easily find people to do this kind of proposed endeavor. You also want to show the officer that there is a difficulty of obtaining labor certification. And you want to show the officer that the national benefit of your work is clear, and this is why labor certification should be waived. All right. So that is how you win your EB-2 NIW case. Remember, in the first prong, you show that your work has substantial merit and national importance. In the second prong, you show that you are well positioned to advance your proposed endeavor. And then in the third prong, you show that on balance, waiving the labor certification will be very, very beneficial to the United States. Okay, any questions so far? Any questions so far? Okay, all right. let's move forward. Now, I'd like to do a strategic comparison between EB1 and EB2 NIW. One of the questions that I get most of the time is people asking me whether they should go for EB1 or they should go for EB2. Now, it is better to go for EB2 with a very strong profile than to go for EB1 with a borderline case. It is better to go for EB2 NIW with a very strong profile than to go for EB1 with a borderline case. So let's look at factors in EB1 and EB2. So as far as standard is concerned, EB1 requires extraordinary ability, and you need to show that you are at the top of your field. You need to show that you belong to the very small percentage of people who have risen to the very top of their field. Now, the burden of proof for EB1 is very high, and you need to show sustained claim. However, the burden of proof for EB2 is moderate. You need to show substantial merit, national benefit. You need to show that you are well positioned to do what you want to do, and you need to show that it will be in the U.S. best interest to waive the labor certification in your case. There is no job offer required if you are filing for EB1 or EB2. There is no perm certification required for EB1. For EB2, it is waived. Can you self-petition? Yes, you can self-petition for EB1 and EB2. That is, you can write it by yourself, or you can give it to a consultant to write, and that's what we help people do. Now, when it comes to visa priority date, for EB1, it is often current. For EB2, sometimes there is a backlog for India or China and other countries, because there are many people that are in line, waiting in line to get their green cards. Now, let me say something, a word of encouragement as far as the visa ban is concerned. I know that people are concerned, especially international students or people are high achieving professionals outside the United States, and that, oh, since there is a visa ban, why should I file for EB1 or EB2? The fact that there is a visa ban does not mean that USCIS will not receive your EB2 or your EB1 case. The only thing is that they will adjudicate it, but they may not give you a final decision. Now, as far as the visa ban is concerned, usually when a ban is in place, it is usually reviewed every 6 months. Every 6 months. So most likely in June or July, there will be a revision, and the ban might be lifted or might not be. But after 6 months, usually these kind of decisions are reviewed. So the president is going to review this decision next month, that is in June or in July, and the president might decide to lift the ban or to keep it. So I just thought to put that out. And looking at the question here. Okay, now can you file concurrently for EB1? Yes, because EB1 is usually, most time it is current. For EB2, you cannot file concurrently unless it is current. Who is EB1 for? For top researchers, executives, artists, athletes, high achieving professionals. Who is EB2 for? For STEM professionals, scholars, entrepreneurs, people in the humanities, and so on and so forth. Now, when it comes to approval, it is more difficult to get EB1 approved than it is to get EB2 approved. So EB1 is harder, EB2 is more accessible. Unless you know that you have really good achievement, EB2 is a good option. But if you are a top researcher, a top executive, a top and high achieving professionals, then you could file for EB1. Now, who qualifies? EB1 typical profiles, they are researchers with significant citations, although you could also be approved without citations. University professors, department heads, senior executives at multinational companies, artists with national and international recognition, athletes with podium finishes, entrepreneurs with acclaimed ventures, and physicians ranked in top of specialty, high achieving professionals. I'm currently studying analytics and apply AI masters in the US. 60% into the program. Please, when do I start applying? You can start applying now, and then by the time you finish your profile, by the time you finish your program, then your petition will have been ready. Then you just submit. So now I usually tell people that now that there's a visa ban in place, that is not the time to go and sleep or sit down. That is the time to build your profile, put in the work, and start writing your petition and start working on your petition. So what is the NIW typical profile? STEM PhD with active research agendas, medical professionals with clinical impact, engineers solving national scale problems, IT professionals in critical infrastructure, educators improving US outcomes, business professionals with traceable impact, social scientists and policy researchers, professionals with advanced degrees. Now, how do I build a winning EB1 or EB2 petition? How do I build a winning EB1 or EB2 petition? The first step is to do an eligibility assessment. So, and we also do that for free. You can send us your profile, and then we'll look at your profile and do an eligibility assessment. So you need to do an honest mapping of your profile to criteria or to prongs. You need to do an honest mapping of your profile to look at which EB1 criteria do I meet, or which prong, EB2 prong, can I meet. You need to know your strengths before you file. Number two, you need an evidence matrix. You need to catalog every piece of evidence. For EB1A, map evidence to each of the 10 criteria. For EB2, you need to know whether you could get letters, you could get things that will help you have a strong profile. You could engage in projects that will show and succeed in them to show that you have handled this kind of things, this kind of project related to your specific endeavor before. So once you know your specific endeavor, you can engage in projects, in conferences, publications that will supplement or show the USCIS officer that you have done something related to your proposed endeavor. Now, expert support letters, 3 to 5 independent expert letters. They need to be specific, substantive, not generic praise. They need to speak to impact. So there are two kinds of letters, recommendation letters. There is the dependent recommendation letter and the independent recommendation letter. So whenever you want to file your case, it is always good to have both the dependent recommendation letter and the independent recommendation letter. The independent recommendation letter is from someone who does not know you, who does not have any professional relationship with you. But the dependent recommendation letter could come from your collaborators, from your supervisors, and so on and so forth. The fourth thing you need is a petition letter or brief. This is the legal art of your case, whereby it applies Kazarian or Dynaza directly to your record. Now, some people use boilerplate. Maybe they get a template from someone somewhere, and then they use the same thing. No, you don't have if you don't have the same profile with the person, you cannot use the same template with that person. You need to have an individualized petition letter or brief to your case. Now, The next thing is citation and impact evidence. Google Scholar printout, citation memos, journal rankings, H-index documentation, and then you need to organize and file I-140 plus filing fee, exhibit list, premium processing was $2,805, but now it has been increased to $2,965. If you're filing for EB1, USCIS promises to get back to you in 15 business days or less. If you're filing for EB2, USCIS will get back to you in 45 business days or less. Now let's look at expert support letters or recommendation letters, what works and what does not work. So what works is, we're talking about independent recommendation letters now. USCIS puts more weight on independent recommendation letters because they believe that independent recommendation letters are not as biased as the dependent recommendation letters. So what works? Expert has no prior working relationship with you. Expert is eminent in your exact specialty. The letter cites your specific papers, project, metrics. The letter explains why your work matters to the field. It compares you to peers, top 5% of colleagues. File for EB1, it addresses specific EB1 criteria or national interest waiver prongs. So it is always good to have minimum of 3 letters. 5 is ideal for stronger cases. So whenever you're filing for EB1 or EB2, it is always good to have 3 to 5 letters. Those letters could be from dependent or independent recommenders. So what fails? From my experience, I've seen that letters with generic praise fail. Oh, Ngozi is a brilliant researcher, or Ngozi is hardworking. That does not tell the adjudicating officer anything about your specific endeavor or about your case. Letters from your own supervisors or collaborators are not as strong as letters from independent recommenders. That does not mean that you should not get letters from your supervisors or collaborators. No, but put more emphasis on getting independent recommendation letters. No mention of criteria or prongs. Expert unqualified in your specific field. That fails. USCIS will not give any weight to that letter. Letter written entirely by the petitioner. Only 1 to 2 letters with no independent expert. No quantifiable impact or peer comparison. So these are things to avoid when it comes to recommendation letters. Now, when you write your petition, most often than not, USCIS might push back and send you a request for evidence. That is called RFE. So when people get RFE, there are different ways to respond to a RFE. Some people get angry, they get mad that after the 6 to 7 months that I put in writing this petition, what does USCIS want again? No, some people just package the same thing and then send it back to USCIS. Some people just sit down and then they begin to mourn, they begin to get agitated, they get angry. No, that is a wrong approach. There is a right approach, a right way to approach a RFE. The RFE is not a denial. It is an opportunity to explain better, to explain further, to be clearer, and to make stronger arguments. So if you file your petition and you get a RFE, it is an opportunity for you to make a stronger argument that will have a lasting impact on the adjudicating officer. Remember, words are spells. That is why we call them spellings. Words are spells. That's why we call them spellings. So when you write, you want to write in a way that your words will impact and will affect the adjudicating officer. Words, whenever you read words, they don't leave you the same. Words always have an effect. So there is a way that you will write that will convince the officer. There is a way that you will write that your officer will see your petition and will say, yes, I am sold. But there is a way that you will write, the officer will not even excuse me, that it will not move the officer. So what you want to do is to write in a way that moves the officer. So how do you respond to a RFE? Number one, you need to read the RFE carefully. Identify exactly which criteria or prongs USCIS says are insufficient. Don't respond to what was not asked. Whenever you are responding to a RFE, do a point-by-point response. Response to all the concerns of the officer. Number two, identify the legal errors. Did the officer apply EB1 standard to an NIW? Recently, I got a RFE whereby it was an NIW case, and I was very, very surprised because I thought that the petition should have been approved. Excuse me. I thought that the petition should have been approved without a RFE. But I saw that the first prong was considered, that the officer says that the petition has substantial merit and national importance, but the second prong was not considered. The officer even said in the RFE that, oh, this person's citation is impressive, but this person has not shown that they have had impact in their field. It was very contradictory. So I could see where the officer was applying EB1 standard to this EB2 case. So what I did was to cite the law back to the officer that, no, you are saying that this person did not have original contribution or major significance. This person is filing for EB2, not EB1. That is EB1 standard, not EB2. So you need to try to identify if there is any legal error. Identify it. Number 3 step, gather new evidence, additional expert letters, new citation data, updated press coverage, promotion letters, salary evidence. One of the mistakes that people make whenever they are responding to RFEs is to send back to USCIS the same package. Don't make that mistake. No. You need, if USCIS pushed back, it means that they were not convinced by the first package that you sent. So look for more pieces of evidence and send it back to them. The first step is write a legal brief, point by point rebuttal. Quote the regulation, apply Danaza or Kazarian with precision. Don't be defensive, but be bold, be assertive. Don't be defensive, be bold, and be assertive. You need to also meet the deadline. Standard RFE is 3 months. Don't rush. Quality beats speed. Don't sacrifice quality on the altar of speed when you respond to a RFE. Do not sacrifice quality on the altar of speed. File early if evidence is ready. And then you need to consider a consultant or an attorney. Complex RFEs benefit from experienced representation. The stakes are too high for generic responses. Now let's look at timelines, fees, and filing options. Regular processing. So this is a budget option. It is acceptable if you are not in a rush. 6 to 12 months, but now today, usually it used to be 6 to 12 months, but today I've had people who filed since 2004 who have not yet heard back from USCIS. So if you are doing regular processing, you will pay $750 plus 300. That is the I-140 fee. That is $1,015. If you are doing premium processing, which is highly recommended for most cases, so it will take you 15 business days for EB1 and 45 business days for EB2. The filing fee will be $1,015 plus $2,965 for premium processing fee. That is the fee that you give to USCIS. Top 5 mistakes that sink petitions. Filing too early. Before you have 3 strong criteria, don't file on hope. File on evidence. Build the record first. When you know that you cannot meet the 3 prongs of EB2 NIW, do not file. Number 2, generic expert letters. Letters that don't mention specific criteria or prongs and don't compare you to peers or are nearly worthless. So do not use generic expert letters. There are certain things that USCIS is looking out for in your expert letters. Number 3, confusing EB1A and EB2 NIW standards. Applying the wrong legal framework in your petition letter. Know which case you are making and stick to it. If you are going for EB1, there is an EB1 standard. If you are going for EB2, there is an EB2 standard, and you need to stick to the right standard. Number 4, ignoring Kazarian step 1. USCIS officers sometimes skip step 1. Don't let them explicitly establish you meet 3 criteria first. Number 5, DIY petition with no legal strategy. Immigration law is complex. Form I-140 is simple. The petition letter is where cases are won or lost. If you have made one of these mistakes, it is not too late. An RFE response or MTR can often recover your case. Are you ready to file? Then you can go to iofx.com or send your profile to us at info@iofx.com. And you can also book a consultation with us. So if you want me to evaluate your case, you can send your case to info@iofx.com. And you can also book a free 30-minute strategy session to assess your eligibility and build your roadmap. We don't just file petitions, we build winning cases. Any questions? What questions do you have for me? What questions do you have for me? Okay. Step Up Academy says, if I have several ways to claim expertise, how do you suggest I go about it to have a solid one for EB1? Okay, that is a good question. So if you have several ways to claim expertise, you go with the expertise that is the strongest on your CV or your profile. For example, what do I mean? If you have worked in supply chain, you have worked in the banking system, you have worked in IT, you look at your profile. If you have spent 3 years in supply chain, of 6 years, 1 year in banking, 2 years in IT, I would suggest you go for supply chain because you have more years there, and chances are excellent that you have more achievement. You have had more achievement in supply chain. So look at your profile critically and look at where you have demonstrated expertise and which part of your profile is the strongest, and that is what you should base your expertise or your EB1 on. And then if you are doing that, you will need to rebuild your CV to highlight that expertise and project forward that expertise, because that is what you want USCIS to see. So if you have expertise in several domains, so you need to rebuild your CV so that your CV can reflect the domain that you want to push forward. How much for your services? Okay, our services go from 3,500 upward depending on your profile. So you need to have a consultation with us. So if you consult with us, what we do is that you pay a consultation fee, and if you decide to work with us, we'll refund you that consultation fee. Like, it will be deducted from your service fee. So the consultation is $150 for 1 hour consultation, and then you can just send an email to info@ifx.com. You can send your profile to info@ifx.com, and then I will review your profile for free. And if you want a consultation as well, you can send an email to info@ifx.com. Any other questions? Okay, if you're yet to subscribe to our channel, please go ahead and subscribe to this channel. And I want to say this: take your immigration journey in your hands. If you are an international student going on the job market with an approved I-140 or a green card, is an advantage, because employers do not want to file. Employers do not want to go through the headache of immigration. So don't leave your future to an employer. Don't leave your future to them. You can self-petition. If you want the fee, you can request for our DIY kit and then write it by yourself, and then we can review it for you. By all means, ensure that you write your petition, you file. Take your immigration future into your hands. Don't wait to say that, oh, I'm waiting for an employer to file for me. No, you can do this by yourself. You can consult with us. You can engage our service and ensure that you put your best foot forward. And the most important thing is for you to get that green card.